Imagine this. You've got a horrific crime that rips through a small town, and that one event sets off a constitutional firestorm. It pits one of our most cherished freedoms, the freedom of the press, against one of our most fundamental rights, the right to a fair trial. Well, that's not a movie plot. That's exactly what we're diving into today.
I mean, this story has all the makings of a legal thriller. You have a brutal murder that shakes a community to its core, and then a judge's decision that, whoa, forces the Supreme Court to step in and draw a line in the sand. All right, so let's set the scene. We're in the tiny town of Sutherland, Nebraska. The date is October 18th, 1975. What happened here on this one day would put this little dot on the map right at the center of a huge national debate. The facts of the case were just brutal. 6 members of a single family murdered. Now, you have to remember, this is a town of just 850 people. Can you imagine the shockwaves? The police moved fast, and a suspect, Erwin Siemens, was arrested. And here's the kicker. He confessed. As you can guess, the story just exploded. The national media swarmed this tiny community.
So you've got this media frenzy, right? And it creates a massive problem. Both the prosecutor and the defense attorney are worried. With all this news coverage, especially about the confession, how on earth could they find an impartial jury? This fear is what led the local judge to do something, well, something pretty drastic.
Judge Hugh Stewart issued what's known as a gag order. He basically told the press, you are forbidden from publishing or broadcasting any details about the confession Simmons made. Now, his goal was totally understandable. He wanted to protect the suspect's Sixth Amendment right to a fair trial. But in doing that, man, he ran headfirst into the First Amendment.
Okay, so this judge's order, it's a textbook example of a really important legal idea called prior restraint. Let's break that down. This isn't about getting in trouble for something you've already said. No, this is the government stepping in and literally stopping you from saying it in the first place. It is, for all intents and purposes, preemptive censorship.
Think of it like this. Subsequent punishment, that's when you deal with the fallout, like a libel lawsuit after an article gets published. But prior restraint is totally different. It's like a government official locking the gate before the words can even get out. It is a way, way more extreme form of control. And, this idea of prior restraint, it's not new. It's actually a really old and, frankly, a hated power. To the American founders, this was the kind of thing tyrants and kings did to shut down any criticism before it could even get started. Fighting against this exact type of power was a huge reason they wrote the First Amendment to begin with.
I mean, just look at the history. For centuries back in England, you couldn't print a single thing without getting a license from the government first. And get this, that system didn't even end because of some grand moral principle. It just got too clumsy and difficult to enforce. The framers of the Constitution knew this history inside and out, and they were like, nope, we are not doing that here.
And this right here, this is what that control actually looked like. The English Licensing Act gave the government complete power to decide what was okay to print. Just imagine a world where every book, every newspaper, every pamphlet had to get a government stamp of approval. It was a complete chokehold on the press.
A hugely influential jurist at the time, William Blackstone, he just nailed it. He defined freedom of the press not as being free from consequences, but specifically as being free from previous restraints. And that idea, right there, became the bedrock understanding that the American founders inherited and then cemented into the Constitution.
So, back in Nebraska, you can see why this was such a huge deal. The whole conflict lands squarely in the lap of the Supreme Court, and it's this heavyweight fight between two foundational American principles. Seriously, think about it. What do you do? How do you choose? Do you protect a free press, even if it means a defendant might not get a fair trial? Or do you protect the trial, even if it means censoring the news to do it? This is the incredibly tough, almost impossible question the court had to answer. And in 1976, they delivered their answer. The case Nebraska Press Association versus Stewart would become an absolute landmark decision, one that's still studied by journalists and lawyers to this day. And the court did not mince words. Chief Justice Warren Burger, who wrote the opinion, called prior restraint, and I'm quoting here, the most serious and least tolerable infringement on First Amendment rights. Wow, I mean, it doesn't get much clearer or more forceful than that. So the court's reasoning was basically, look, the judge went straight for the nuclear option here. There were so many other things he could have tried first. He could have moved the trial to a different town. He could have delayed it until things calmed down. He could have been way more careful when questioning potential jurors to screen out bias. Or he could have even sequestered the jury, basically put them in a bubble, shielded from the news for the whole trial.
And this gets to an even bigger point the court was making. The press isn't the enemy of the justice system, it's a crucial part of it. It acts as the public's watchdog, keeping an eye on the police, the prosecutors, and even the judges to guard against a miscarriage of justice. After all, a trial held in secret is not a fair trial. So this ruling had a massive, lasting impact. It essentially unleashed that watchdog, reaffirming the absolutely vital role of a free press in a democracy. And here's maybe the most stunning fact of all. The decision was 9-0, unanimous. In a case with such a tense conflict of rights, all 9 justices came together with one powerful voice to say that censoring the press is almost never the answer. Yeah, legal experts called it a great victory for the press, and for good reason. The court didn't say a gag order could never happen, but it set the bar so incredibly high that it's become practically impossible for a judge to justify one. The danger from publicity would have to be immediate, intense, and have literally no other solution. And of course, that brings us to today. In our world of social media, where a story can circle the globe in seconds, could a judge's order ever truly stop information from spreading? And if it can't, what new challenges does that pose for guaranteeing every single person their fundamental right to a fair trial? It's a question we're still grappling with.